Okay friends, now the next most important topic, that is the pardoning power of the president. See friends, Article 72 of the Constitution empowers the president to grant pardons to persons who have been tried and convicted of any of the offences in all the cases where the punishment or the sentence for an offence is against a union law, or the punishment or the sentence is by court martial and the sentence is a sentence of death. The pardoning power of the president is independent of the judiciary. Friends, please remember that the pardoning power of the president is independent of the judiciary. It is an executive power. It is not a judicial power. It's an executive power. But the president, while exercising this power, does not sit as a court of appeal. The object of conferring the power to the president is twofold. One, to keep the door open for correcting any judicial errors in the operation of law, and to afford relief from a sentence which the president regards unduly harsh. Okay friends, moving on. The pardoning power of the president includes the following. First is pardon. It removes both the sentence and the conviction and completely absolutes the convict from all the sentences, punishments and disqualifications. Friends, please remember that pardon removes both the sentence and the conviction and completely absolves, that is, he is no longer a convict and he is also of his sentences are also removed from disqualification. Next is commutation. It denotes the substitution of one form of punishment for a lighter form. For example, a death sentence may be commuted to a rigorous imprisonment, which in turn may be commuted to a simpler imprisonment. Okay? Commutation means it does not change the form of the punishment, rather it reduces the intensity of the punishment. Next is remission. It implies reducing the period of the sentence without changing the character. For example, a sentence of rigorous imprisonment for 2 years may be remitted to rigorous imprisonment of 1 year. Next is respite. It denotes awarding a lesser sentence in place of an originally awarded sentence due to certain special facts. Some of the greatest examples may be like the case of Nalini, who was accused in the murder of our ex-Prime Minister Shri Rajiv Gandhi. She was given this respite from death sentence to life imprisonment because she was pregnant at the time of her sentence. Next is reprime. It implies the stay of execution of a sentence, especially that of death sentence, for a temporary period. The purpose is to enable the convict to have time to seek pardon or commutation from the president. Moving on. Under Article 161 of the Constitution, the governor of the state also possesses the pardoning power. Hence, the governor can also grant pardons, reprimes, respites and remissions of the punishment, or suspend, remit and commute the sentence of any person convicted of any offence against a state law. But the pardoning power of the governor differs from the president in the two respects. Friends, these two aspects in which the pardoning power of the president differs from that of the governor is very important, and usually the examiner focuses this area while asking questions. Number one, president can pardon the sentences inflicted by court martial or military courts, while the governor cannot do that. It is a very important point. Next, the president can pardon death sentences while the governor cannot. Even if the state law prescribes death sentence, the power to grant pardon lies with the president, not the governor. However, the governor can suspend, remit or commute a death sentence. In other words, both the governor and the president have concurrent powers with respect to suspension, remission and commutation of a death sentence, but pardoning power is only with the president. The Supreme Court examined the pardoning power of the president under different cases and laid down the following principles. The petitioner for mercy has no right to an oral hearing by the president. The president can examine the evidence afresh and take a different view from the view taken by the court. The power is to be exercised by the president on advice of the union cabinet. Friends, please remember, this power can be exercised by the president only on advice of the union cabinet. The president is not bound to give reasons for his order. The president can afford relief not only from sentence that he regards as unduly harsh, but also from an evident mistake. Friends, please remember these points, okay? Even if there is a case of an evident mistake, he can use his pardoning power. There is no need for the Supreme Court to lay down specific guidelines for the exercise of power by the President. The exercise of power by the President is not subject to judicial review except when the President's decision is arbitrary, irrational, malafide or discriminatory. Where the earlier petition for mercy has been rejected by the President, stay cannot be obtained by filing another petition. What is the constitutional position of the President? The Constitution of India has provided for parliamentary form of government. Consequently, the President has been made only a nominal executive. The real executive is the Council of Ministers headed by the Prime Minister. In other words, the President has to exercise the powers and functions with the aid and advice of the Council of Ministers headed by the Prime Minister. Dr. B.R. Ambedkar summed up the true position of the President in the following ways. In Indian Constitution, there is placed at the head of the Union. He is placed at the head of the Indian Union as a function, who is called the President of the Union. The title is functionary. The title of the functionary reminds of the President of the United States, but beyond the identity of the names, there is nothing in common between the form of government prevalent in America and the form of government adopted under the Indian Constitution. The American form of government is called presidential system of government, and what India adopted is the parliamentary system. Under the presidential system of America, the President is the chief head of the executive and the administration is vested in him. Under the Indian Constitution, President occupies the same position as the King under the English Constitution. He is the head of the state, but not the executive. He represents the nation but does not rule the nation. He is a symbol of the nation. His place in administration is that of ceremonial device or a seal by which the nation's decisions are made known. He is generally bound by the advice of his ministers. He can do nothing contrary to the advice, nor can he do anything without their advice. The President of the United States can dismiss any secretary at any time. The President of the Indian Union has no powers to do so, so long as the ministers command a majority in the parliament. Friends, please remember these differences. These are very vital points for your mains exam. In estimating the constitutional position of the President, particular reference has been made to the provisions of Article 53, 74 and 75. These are: number 1, the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. That is Article 53. There shall be Article 74. There shall be Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall in exercise of his functions act in accordance with such advice. That is Article 74. The Council of Ministers shall collectively be responsible to the Lok Sabha. That is Article 75. This provision is the foundation of the parliamentary system of government. The 42nd Amendment Act of 1976, enacted by Srimati Indira Gandhi government, made the President bound by the advice of the Council of Ministers headed by the Prime Minister. The 44th Constitutional Amendment Act of 1978, enacted by the Janata government headed by Sri Morarji Desai, authorized the President to require the Council of Ministers to reconsider such advice, either generally or otherwise. However, he shall act in accordance with the advice tendered after such reconsideration. In other words, the President may return a matter once for reconsideration of his ministers, but the reconsidered advice shall be binding. In October 1997, the Cabinet recommended President K.R. Narayanan to impose President rule under Article 356 in Uttar Pradesh. The President returned the matter for reconsideration of the Cabinet, which then decided not to move ahead in the matter. Hence, the BJP-led government under Shri Kalyan Singh was saved. Again, in September 1998, the President K.R. Narayan returned a recommendation of the Cabinet that sought to impose President's rule in Bihar. After a couple of months, the Cabinet re-advised the same. It was only then the President's rule was imposed in Bihar in February 1999. Though the President has no constitutional discretion, he has some situational discretions. Friends, please remember situational discretionary powers of the President, because the powers of the President can also be classified as situational discretion and constitutional discretion. Number 1. In other words, the President can act on his discretion, that is without the advice of the ministers, in the following situations: appointment of the Prime Minister when no party has clear majority in the Lok Sabha, or when the Prime Minister in the office suddenly dies and there is no obvious successor. Dismissal of the Council of Ministers when it cannot prove the confidence of the Lok Sabha. Dissolution of the Lok Sabha if the Council of Ministers has lost its majority. Okay friends, these are the situational powers of the President. Friends, President topic is very important topic. All the points you need to remember very clearly, because there is a possibility of questions being twisted in this regard. It is the most important topic if you ask me. If I classify 10 very important topics from polity, then President is definitely a very hot topic, friends. Okay, so please do not forget to revise this chapter again and again and practice as many questions as possible, because there is a very high possibility of questions being asked from this chapter. Okay friends, please do not neglect this topic. In case of any doubts, read the topic again, listen to the lecture again, and in case of any further doubts, you can always contact us. Okay friends, thank you friends, thank you very much, have a great day.